Right, good evening, everyone. I think we'll make a start. There will inevitably, I think, be a few late stragglers. A very warm welcome to you to this first event by the 42 Bedford Row employment team since, I won't say the word, but I can't tell you how lovely it is to see so many of you in person after seeing people on a screen for so long. Although we've all been hiding away for the past 18 months in our kitchens, in our back bedrooms, in our sheds, whatever your office or CVP courtroom of choice is, we haven't been standing still at 42 Bedford Row. There's been lots happening. We've obviously been busy, and I'm pleased to say that we've grown as a team since March 2020. So we've been delighted to welcome no less than 9 new members of the team. We've had Gillian Crew, Michael Salter, Amy Stroud, Kath Urquhart and Jonathan Davies have all joined us in that time, bringing a wealth of employment law experience to the team. And we're also delighted that Catherine Archer, Andrew Carter, Charmaine Clubb and Rob Winspear have all joined us as tenants on successful completion of their pupitres, so bringing new talent to the team. So I hope you can meet as many of those new faces as possible this evening, as well as old friends. You all have found packs on your chairs that have copies. Actually, I don't know, there aren't copies of the slides in the packs, are there? But no. So, but they will be available afterwards. I mean, you've got details in there, and I think some paper. I'm sure you're going to have lots of questions arising out of what are going to be pretty thought-provoking topics this evening. But so if you could jot down any questions that occur to you as you go along, we'll have a session at the end for any questions. We're also going to have a short break in the middle so that you can grab a drink and collar any of us to ask questions about anything. And then, of course, we will have plenty of opportunity at the end to both deal with questions and also hopefully enjoy a drink and some canapes. So without, and I should also say that you have a programme with speakers in there. In the great tradition of the bar, of course, some people who were due to speak are now stuck in far-flung employment tribunals somewhere. And so Andrew Carter has very kindly stepped in for Christy Scarborough, and Aysha Ahmad is stepping in for Sophia Through. So without further ado, I'll hand over to our first speaker, Iris Ferber.
We start with my session, The Brave New World. Now, there are decades where nothing happens, and there are weeks when decades happen. And 23rd of March 2020 to the 1st of September 2020, those were 22 weeks, weren't they, when decades did happen. For many people, work stopped. But not only work, commuting stopped. The concept of the working day stopped. Timekeeping stopped. Come on, sit down. Management stopped. Teamwork stopped. And when things did start up again, they weren't the same, were they? So what's been the effect of the pandemic on the world of work? Disruption, or acceleration, or revolution? Well, it's all of them, isn't it? I think we can see that in some of the major themes that I think are going to change the world of work in the next decade. I'm going to suggest 3 themes that are going to be important in the next 10 years. I'm sure you can think of other ones. This is where I lose my clicker. Yeah. Theme number 1. Automation, or more accurately, digitization. Let me take you back to 1971, the year of Sweet Caroline, ba, ba, ba. And I can't do the next one, I'm afraid. Sorry, Jason. No. Ernie, the fastest milkman in the West. It was a great year, 1971, and it was also the year of the Industrial Relations Act. What did the Industrial Relations Act 1971 create? You all know, don't you? Jude knows. Jude remembers it. It was the concept of unfair dismissal. So 1971 is really the start of employment law. And in that same year, when a fully loaded ship docked at the Liverpool dockyard, it would take 108 workers 5 days to unload it. 108 workers, 5 days. By the year 2000, the same task at the Felixstowe docks took 8 workers 1 day. That's a 98% reduction in working days. From 540 days to 8. Why? What enabled that massive change from 1971 to 2000? Containerization. Those big metal things you see every day on the back of lorries. They're all an identical size, they have identical fittings, and an entirely automated system is built around them. They are packed once at the factory, and they are never unpacked until they get to the end of their journey, to the final warehouse. So containerization revolutionized logistics. And digitization is the containerization of services. And let me give you an example to show you what I mean. In the year 2000, the Tesco Express near your office had 4 tills. And there were staff on those tills working 3 shifts a day. So that is 12 staff to work the tills at your Tesco. But in 2021, at that same Tesco Express, there are 6 tills, aren't there? Not 4. But they are self-scan tills. So there's only 1 member of staff on 2 shifts managing those self-scan tills. That's 12 people down to 2 in 20 years. And perhaps, maybe it's not a perhaps, maybe it's a definite, I don't know. By 2031, all the supermarkets will have followed Amazon Fresh, won't they? And customers will be doing everything in these supermarkets themselves. They'll be doing the checkout all by themselves using a smartphone, and there'll just be 1 member of staff on the door in the entire store for security. Or what about Lloyds Bank? They've just announced that they are closing another 48 branches. That's an announcement that was made 3-4 days ago. They closed 44 in June of this year. And how can they do that? How can they lose so many branches and still function as a bank? Well, it's because, isn't it, everyone, even my 78-year-old mother-in-law is now doing all their banking on a smartphone since the pandemic forced everyone to get into that. And what is a smartphone? What is a smartphone? It's a container, isn't it? It's a digital container, and it standardizes all of us as consumers, and we now fit into a lot of different systems that can be much more efficient than they were before. So I think that's going to have profound effects on the world of work in the next 10 years in lots of different ways that we can't possibly imagine. The second theme, I think, of the next 10 years is delayering. Who hasn't had a client in the last 2 or 3 years doing a restructuring exercise that involved delayering? So moving from a hierarchical management structure to a flat management structure and removing middle management jobs. I think that process is going to be exponential in the next 10 years. And the third theme, I think, for the future is autonomy. Let me tell you a story. I bet most of you will have a similar one. My brother-in-law has had many, many jobs over the years. He's been a car salesman. He's worked in a tile showroom. He's been a carpet fitter. He's worked in small local businesses. He's worked as an administrator for national companies. He never stays in any job more than a couple of years. He always gets annoyed with someone, usually his line manager, and he quits. Now, at the moment, he's working for an insurance company. He was working in a call centre. He'd been there for about a year when the pandemic struck. And he was packed off home to work from home with a computer, headset, log in to the company intranet. He loves it. He can start as early as he likes. He uses his old commuting time as overtime in the morning. He clocks up his overtime. He wears whatever he wants. He has a cigarette break whenever he wants. Nobody cares. He doesn't have a commute. And here is the key. His contact with his colleagues and his managers is much less frequent, but it is much more effective, and it suits him perfectly. He's the happiest he's ever been. Maybe he will stay in that job. And his employer absolutely loves it. They've told him he can stay working from home permanently. So that autonomy, that possibility of autonomy, I think, is a theme for the next 10 years of work. So you're going to hear 6 talks this evening. Some of them were going to involve some softer themes: flexibility, freedom, workplace dynamics. And some of the themes are going to be very sharp and very precise: vaccination, holiday pay, loss of salary. And the common thread that runs through them is the prospect of tribunal litigation. And so we will close our evening with some very wise words on a subject which is very close to all our hearts here, I think, very personal. How have the tribunals changed during the pandemic? And how do we avoid embarrassing ourselves when appearing before remote tribunals? So that's all to come. But first, you're going to hear from Jill Crew.
Thanks very much, Iris. I'm going to be particularly looking forward to the How Not to Embarrass Yourself in CVP hearings. I'm still waiting for that experience. So I'm going to talk to you tonight, hopefully if I can get the slides working. Yes. No jab, no job. The issue of mandatory vaccination meets employment law. What strange times we live in. I never thought I'd be giving a talk on this sort of thing, but here we are. So it's hot off the press. No jab, no job. Came in on the 11th of November for the care home sector under the 2021, the catchy entitled Health and Social Act 2008 Regulated Activities Amendment Coronavirus Regs. And what that says is that B cannot enter a care home unless it's provided A with evidence that satisfies A that B has been vaccinated, or that for clinical reasons B should not have the authorised vaccinations. Now, we know from this week just gone that that's also going to be extended now to NHS frontline staff from the 1st of April 2022. And what do these 3 people have in common? Well, we've got JP Morgan, we've got Google, we've got the lovely Charlie Mullins of Pimlico Plumbers. They are also all private employers, and they're also all bringing in mandatory vaccination policies of some form. So Mr. Mullins, although obviously he denies he has any employees, for his workers, they've all got to have mandatory vaccination for going forwards. I think that's quite brave, but here's the conundrum, isn't it? This is where we're at and why we find ourselves in a totally different landscape. The tension, protecting the most vulnerable in our society. I don't think any of us would have a problem with that as employment barristers, whether you've got friends or family in care homes or accessing staff, accessing healthcare regularly. That's not a problem. But then we have the tension, don't we? We have a government at the moment that doesn't mandate the wearing of face masks, for example. It doesn't mandate vaccine passports for entertainment purposes, but does say in these regulations that if you're not vaccinated, we'll take away your job and essentially your ability to put food on the table. So there is a tension there. And there's also the issues of staffing, because as of the end of October 2021, only 89.4% of care home staff are fully vaccinated. Now, fully vaccinated for the purpose of the new regs means 2 doses. It doesn't mean the booster. So that leaves just shy of 50,000 staff not having received the 2 doses. So that's 1 in 10 staff in the care home industry. Obviously, that's going to cause an imminent staffing shortage. Before we look at the potential interface with employment law and claims that could be brought, let's think about why. Why is this happening? Vaccine hesitancy. So that's defined as either a reluctance or a refusal to have what is a safe vaccine. I thought it was interesting when you actually look at the industry that we're talking about here. So care home staff, it's not the highest paid staff in the world. So this is minimum wage workers. This is minimum wage workers who, when you see them on the news, they're saying, we love this industry. But they're concerned about, the things that I heard was they're concerned about the future possibilities, future side effects of the vaccine. So I've looked at some studies and I've put together a paper which will come out after this talk, and so which will give you more details because I haven't got the time to go through everything tonight in 15 minutes. There's lots of interesting data out there, and the vaccine hesitancy is one such interesting area to look at. 2 studies, one of individuals talked about, and there was in America and Canada and US and Australia, talked about the lack of trust in the government as the driver behind vaccine hesitancy. British Medical Journal had a look and they identified understandably different factors. They identified socioeconomic and healthcare inequalities, structural racism, and also I think more interestingly for us possibly, misinformation, particularly through social media. Again, this is very much a 21st century phenomenon. So where does it leave us? We have what appear to be genuine reasons and genuine concerns about vaccine hesitancy, but we have this mandatory vaccination. What are the claims that we could be looking at? I think most of us would feel that just in your gut, it doesn't quite feel fair that you're going to lose your job. But is it an unfair dismissal? No. I think the good news for the employer, as far as unfair dismissal, no. This is clearly going to be, from now on, a potentially fair dismissal. And I say that because of Section 98(2)(d) of the ERA. So that is where you're contravening a duty or restriction imposed by or under an enactment. Likewise, let's think about SOSA, Section 98(1)(b), some other substantial reason. And it seems to me that continuing to employ an individual who's not fully vaccinated will be a substantial reason justifying dismissal. The regulations themselves do not make continued employment illegal, so it's not like a case of where someone's got immigration issues. But what it is not a redundancy. There is no ceasing or diminution of the need for the workers. Indeed, because of the numbers, there's going to be an increase in the need for the work to be carried out. But just because there's not a redundancy situation, I would suggest that collective consultation as well as individual consultation has got to be sensible. And what consultation needs to take place? Well, we still have, even if you have a potentially fair reason, Section 98(4), you've got to carry out a fair procedure. So you need to consult with the employee. You need to come to understand why the vaccine hesitancy. You need to look at whether there are any potential for redeployment. You need to look at an appeal. So unfair dismissal may not be a problem. Disability, I think, is a potential problem for employers, and that's where we're going to see the claims being made, particularly in relation to indirect discrimination. So is it going to be a direct discrimination claim under Section 13? No. Whatever happens to the employees when they lose their job, it's not because of any protected characteristic they have, it's because they're vaccination stated. Is it indirect under Section 19? Possibly. Think PCP, think group disadvantage, think particular disadvantage, and then subtract the potential objective justification. Is there a Section 15, something arising claim? Potentially, yes. If there's something arising from the disability, it's the inability to have the vaccine. So the potential protected characteristics. Disability. On the face of it, seems like a potential claim there, doesn't it? Because we know that there are groups that cannot have the vaccine, for example, if they are severely allergic. We know that there are some groups for whom the vaccine is not suitable, if, for example, they are immunosuppressed either by a condition or as a result of cancer treatment. So that could be the Section 15, something arising. But it seems to me that the answer in relation to all of those claims is that that's going to fall within the clinical reasons exemption. So I don't see that that's going to be an issue. And likewise, if you're unable to get a vaccine, that's a normal day-to-day activity. So you're likely to fall within the statutory definition of disability. And the duty to make reasonable adjustment therefore applies. So as an employer, you're going to have to be looking at redeployment. In the right circumstances, you might have to be thinking about creating a new role. Pregnancy. This was an interesting one when I was looking into this, because I do think that this potentially is a claim there. Not Section 19, remember, because unfortunately pregnancy and maternity is not one of the protected characteristics that indirect applies to, but sex is in there. Likewise, a claim could be brought either under Section 18 itself or under the MAPLE regs. It's interesting because of the change of advice. So at the beginning of the pandemic and when the vaccines first started to come through, the advice was that pregnant women should not get vaccinated. That has subsequently changed. So the official JCVI advice now is that as you work through the age groups, you should get your vaccine even if you are pregnant. But this week was interesting because I saw in the news that with the vaccine data of all of the pregnant women who are hospitalised with COVID at the moment, 98% are not vaccinated. So there is an indirect type claim potentially there, I think. Leads me on to sex. That is one of the protected characteristics. There's a December 20 study which was asking about 50,000 people. And the largest group of people who said they might not take the vaccine were women between the age of 18 and 34 who are looking to start a family. On the face of it, there is some scope there, but that's not made out in the vaccine data, so I don't think that's an argument that's going to work. Likewise, age was mooted to be a potentially indirect discriminatory argument on the basis that younger people have higher risks from the vaccine and yet lesser risks from actually contracting COVID. But again, that's not actually made out on the data, so I don't think that's going to get there. But race is an interesting one. And it's interesting because the vaccine data shows us a real discrepancy in the uptake within some of the ethnic groups. Like, just get the right bit on the slides. So, So in January 2021, a UK study found that 71.8% of black ethnic groups said that they were unlikely to have the vaccine. That was followed by 43% of Pakistani and Bangladeshi also expressed vaccine hesitancy. It's made out by the vaccine data. So by April and May 2021, looking at those over 50s, only 64% of black over 50s were vaccinated in comparison to 93% of white people. So there's potentially a claim there. I'm not going to look at the reasons other than to say that they are genuinely held reasons, concerns about the future effects, but nonetheless it does seem to potentially open the door. Religion or belief. Various concerns have been raised about the vaccines from different religious groups, from Muslims through to vegans. We know, of course, that veganism is a protected belief under Section 10. The concerns arise out of the contents of the vaccine and also whether it's been tested on animals. Those are not issues that in any way would fall within the clinical reasons. So I think potentially in relation to some of those groups there is an indirect argument that could be made under Section 10 and religious or philosophical belief. And how about the more controversial anti-vaxxers, those that genuinely believe that vaccines are harmful to public health? Are they going to satisfy the Granger test? The Granger test being, of course, is it cogent? I suspect not. That I don't think that the anti-vaxxers will be able to satisfy the 4 tests in Granger and Nicholson. But certainly the argument is there. But even if we get through establishing the PCP, establishing the disadvantages that is necessary, justification, defence, legitimate aim for mandatory vaccination, I think respondents are going to be really home and dry on certainly establishing this in relation to care home staff and also for frontline staff. Even EHRC, when they answered the consultation, accepted that. They said that it was reasonable, particularly when we're looking at the right to life for residents of care homes. But what happens when we start to move away? So how about Mr. Pimlico plumbers? What happens when we move away from the care homes? What happens when we move away from the hospitals and we go to office staff? Is the justification, defence and legitimate aim as strong? And most importantly, when it comes to proportionality, is this a sledgehammer to crack a nut? We've got to think about the MELAT test. You've got to look at not only as to whether the legitimate aim is justified, but whether there are less intrusive measures. And I think there are less intrusive measures, certainly maybe not so arguable in relation to care homes or frontline staff, but NHS staff, but think about mandatory PPE, daily lateral flow tests. Clearly the mandatory PPE doesn't work for care homes, it doesn't work for NHS frontline staff because they already have to do that. And I suspect they also have to regularly laterally flow tests as well. But when it comes to other work environments, such as the office, aren't those less intrusive? Don't they achieve the same aim? These are all the sort of questions that we're going to be looking at over the next 18 months or so. And I think that it's going to be proportionality is where the real fighting ground is going to be. Because it seems to me that looking at the data, the PCP is there, the data is there that shows the disparate treatment in different groups. What we need to ask ourselves is, come back to the question, is this the sledgehammer to crack a nut? And the arguments may not succeed under the 2021 regs in care homes and NHS frontline staff, but I think we'll be having these arguments in relation to private employers for certain. So, eyes peeled for litigation. There was a potential judicial review of the 2021 regulations brought by some disabled care home staff. I don't know where that's got to. It was back in court, I think, last week. It's all gone quiet on that. It's one of the crowd-funded ones, so I can't give any update on where that is at the moment. But we're definitely going to be seeing employment tribunal claims, which is a good thing, particularly as Iris was saying that we're getting rid of people. So it's a good thing that we're going to be having more employment tribunal claims. But of course, subject to our friend, the backlog. So when are we going to start seeing the answers to some of these really interesting questions? Well, it's certainly not going to be in 2022, and I don't think it's going to be in 2023. It's probably going to be a bit longer than that. But there's some really interesting questions that we need to ask ourselves, whether what is a really good aim to protect the most vulnerable, whether the way that it's being done is proportionate. So we'll see. But that's all I wanted to say for the time being. So I've got lots more in the notes, but it's just simply not possible to go through it all at this time. But you can read those at your leisure. Thank you very much for listening. I think it's over to Aysha now.
Thank you, Jill. Thank you, Iris. So I'm going to be talking about Section 20, reasonable adjustments, and whether you think in the post-pandemic climate those have to be more reasonable, or whether the new normal has changed. But I'm going to start with the legal framework a little bit, because the end point, of course, that we have to enter is the employment tribunal context, and how you pitch your claim and how you advise your clients to start with is kind of important to whether or not you're going to succeed. So to start with, what is your PCP? Does it put the disabled person at a substantial disadvantage, not a trivial minor disadvantage, a substantial disadvantage? So think about that through the lens of the pandemic, the lockdown. What are the disadvantages that disabled employees are likely to be facing? In comparison with persons who are not disabled, so those who are able to travel in with restrictions, who are able to perhaps not be as vulnerable to being infected as those who are disabled. If there is a substantial disadvantage, then the employer has got to take such steps as it is reasonable to have to take to avoid that disadvantage. So that's the legal framework, and it remains the same in post-pandemic times. But a word of warning on your PCP. This is where most Section 20 claims often fall down, because it is sometimes drafted in a way where it isn't actually a PCP. It's a one-off act. There are examples of where it has not been followed. and that's a problem. And so consider whether or not you're better off with the facts that you have, pitching it as a Section 13 and more often than not a Section 15 something arising claim, because you will get your claim struck out at the beginning, right at the start, if your PCP is not well formulated. Now, the question that it's interesting to think about post-pandemic, in the post-pandemic context, is, well, what is reasonable? Is reasonable still what reasonable used to be for Section 20? Well, by and large, yes. All of the reasonable adjustments that were previously made by employers and that were considered reasonable remain reasonable. So, for example, widening narrow passages, providing ramps, providing specialist chairs, all of those reasonable adjustments remain reasonable because we're familiar with them. We know about them. We've sort of grown up in the employment law world with them. And previously we were always told, well, think holistically, think about the practical outcome. Don't just make an adjustment that doesn't actually ameliorate the disadvantage. It has to be effective. If it isn't effective, it's not reasonable. All of those principles still apply to adjustments in the pandemic or post-pandemic. Same principles apply to cost and the resources of an employer. So when you're thinking about, is it reasonable because it's too expensive? Well, actually research what the cost is, because quite often employers haven't done that. And so when they're put on the spot about, well, did you take costings? They actually haven't. They've just decided that it's not cost effective. Don't consider it in the context of one branch. If you're a multinational organization, the tribunal will look at it across the board for your organization, whether the cost was reasonable or not. So when you're thinking holistically in the context of adjustments for the post-pandemic situation, I would invite you to think outside of the box and really do some blue sky thinking, because quite often you'll be surprised how quickly counsel on the other side, counsel for the claimant and the judge, can think at the drop of a hat of a few things you could have done or your clients could have done to ameliorate the disadvantage for a disabled employee. And so the question really is that, has the normal changed, and do you have to be more reasonable when you're making your reasonable adjustments? Well, the normal has changed. What used to be the usual arguments that employers used to make, well, this is just not viable. We can't possibly have so many people working in this manner or working in these locations. Well, the world has turned on its head, and it turns out that actually businesses can function. Not all businesses suffered losses. Some actually did rather well economically. And so the normal has changed. You'll hear later from Jason about flexible working, so I'm not going to touch upon that. But you have to be a little bit more flexible in how you advise and how you advise your clients to approach what's reasonable now, because the norms have changed. So when you're thinking about being creative in the physical workspace, if an employee who is disabled is a little bit reluctant to come back because they may have only had 1 week or 2 weeks since their first vaccination, and there's material available medically on how many weeks post whichever vaccine it is that it's likely to have kicked in. In that period, if a disabled employee is saying to you, I feel particularly vulnerable, or saying to your clients, and you say, well, actually, you know what, the workplace is as it is, we can't really accommodate you. Well, think about whether or not there's a separate room where the social distancing would be possibly better, and you do ameliorate the disadvantage because they're more at risk. So it's not impossible in the physical workplace to put in adjustments. Giving clear face masks to colleagues of those employees who have hearing impairment. It's a simple thing, but it actually removes the communication problems of an employee who cannot hear in a workplace where everybody is wearing masks. So sometimes it's not about cost, it's really about thoughtfulness and a little bit of, approaching it from a problem-solving angle, which is in fact what the law requires you to do. It's got to be effective, it's got to be practical, it's actually got to remove the disadvantage. And then the other sorts of reasonable adjustments, the technological adjustments, those also in the pandemic, post-pandemic landscape, require a little bit of tweaking and a little bit of thought and consideration. So consider what sort of speech or text providers you may engage. Consider BSL interpreters. Consider specialist phones, because it's now not an exception. It now is the norm. So if you're considering a chair for a disabled employee, think about whether the delivery company are allowed to come in, or whether the disabled employee is in fact shielding, or whether health and safety will allow the person who is going to assemble the chair to enter the home and assemble it. So what you need to do to avoid another 8 weeks of delay and this person not being engaged in the workforce, maybe make inquiries about whether the chair can arrive pre-assembled. So it's really about grappling with the situation that COVID has created and making adjustments that will work in order to make sure that you do not lose employees who are disabled, who are productive and are adding to your company or your organization's productivity, but also that you are not putting off potential disabled employees who could turn into valuable members of your workforce. So it's really to avoid loss of talent that you need to think a little bit ahead of the curve. And then I'm going to move on to a very interesting area in relation to making reasonable adjustments for disabled employees, and that's that of mental health. One of the things that is well documented following on from the pandemic is the impact on the workforce with mental health. Whether those employees are disabled or not, what you don't want is that employees who are healthy become disabled, because as you know, it's 12 months. And the definition is not difficult if you are spiraling with mental health difficulties and depression and anxiety and stress. So where you are making reasonable adjustments for disabled employees, do not make assumptions that hybrid working suits them or is for everybody, or actually should we just make all of our disabled employees work from home because they'll love that. That's not actually the case. You heard Iris talk about her brother-in-law thriving in a work environment where he's at home and he's excelling. However, quite often those individuals with disabilities also grapple with mental health issues. Sometimes the physical disability or the mental disability will create autonomy is something you need to think about. Isolation is something you need to think about, and lack of social integration is something you need to think about. I did a case recently where an entire office building was closed down. The disabled employee didn't want to work from home because the disabled employee felt she was already very isolated, and actually going into the office allowed her to to participate more meaningfully and really improved her mental health. So, of course, the employer hadn't thought of it, but a reasonable adjustment that she was agreeable to was going to an office that was a few miles further out. It meant her commute was 30 minutes longer, but twice a week the employer was happy to pay for her to have a taxi to go to another location so that there was interaction with other members of staff. So there are things you can do even when the world is locked down that will facilitate and make adjustments for mental health and avoid stress and avoid you having long-term sickness absence to deal with. Things like we know that all sorts of services are being provided online. Think about an adjustment of providing online counselling to employees. When you have returned to work, if there's even a whiff of an adjustment being required before it's requested, perhaps suggest online counselling. I have recommended to clients that they look into yoga, where there is a preponderance of back problems emerging. You need to think outside of the box. It's an environment that is new to everybody. So if you as employers think, well, the person who's experiencing it surely should make suggestions. Well, the law doesn't require the employee to tell you what reasonable adjustment to make. You as an employer have to think of it. So here, neither the employee has had experience of it, nor have you, nor has your client. So both of you need to sit down and have a conversation about how best to remove the disadvantage that disability is creating, or a situation in the workplace is creating. So I would like to end with a quote which I think is particularly poignant, even more so in a crisis that is global. And it's a quote from Gandhi, and he said that the true measure of any society can be found in how it treats its most vulnerable members. And I think that we all do very exciting jobs, because to some extent we are at the cutting edge of social, societal engineering. We are advising on how to make life better for people who are vulnerable, creatively and intelligently and compassionately. And so I hope that you will take that away and provide some thought to those organizations that you are advising. Thank you very much. Andrew?
Good evening, everyone. On the 23rd of March 2020, the UK went into nationwide lockdown, with people ordered to stay at home to save lives. And 3 days later, the government introduced changes to the no carryover rule on annual leave, allowing workers in some circumstances to carry over their leave into the following 2 leave years. I'll be looking this evening at the terms of the exception to the no carryover rule, some of the guidance that has been issued, and then offer my view about how the tribunal is likely to approach claims for carried over leave. The exception arises from the creatively named Working Time Coronavirus Amendment Regulations, and it allows workers to carry over their leave where, first, it's not reasonably practicable to take some or all of the 4 weeks of leave under Regulation 13, so it's not for the full amount of leave. Third, that the inability to take that leave must be as a result of the effects of coronavirus, and that includes expressly the effect on the worker, the employer, and the wider economy and the society, so incredibly broad. And if those matters are satisfied, the worker can carry over their leave into the next 2 leave years. So the question for us is, what does not reasonably practicable actually mean? And the first port of call is the context. So we can see, firstly, that the relevant causative effects of inability to take leave because of coronavirus are very broad, as I've just outlined. And secondly, that the question about whether you can carry over leave is not connected to the worker giving notice that they want to take leave, and it's not connected to the employer saying, no, you can't take that leave. So we have this enormous universe of potentially relevant facts in circumstances where potentially nobody has spoken about leave. So I would suggest that the words in context so far suggest that we're talking about a very fact-sensitive inquiry, which I often think when I see those words, it depends on the judge. What about the guidance that has been issued? And I'll just move on to the next slide. So Bayes has issued some guidance, and I would argue that the Bayes guidance is focused on the capacity of the employer to be without the worker. So, for example, it's relevant whether the business faced an increase in demand due to COVID that would reasonably require the worker to continue working. Secondly, the extent to which the business's workforce was disrupted and the practical options to provide cover. Third, the health of the worker and how soon they need the rest and relaxation. The amount of time that's left in the worker's leave year, and the effect of taking the leave on the wider society's response to the pandemic. So I'm not sure that every worker is going to be working in a job where what they do has an effect on the social response to the pandemic, but there are certainly workers who absolutely do, and that could extend, I think, to stacking shelves at a supermarket, as well as, of course, working as a carer. There has been some further advice from ACAS, and I would say that the ACAS advice has a different perspective. It takes a different slant on things. And the ACAS guidance is more focused on the needs of the worker. It gives examples of it not being reasonably practicable to take leave where the worker is self-isolating or too sick to take leave, or they've had to continue working. They don't explain what do we mean by unable to continue working. It could be for any number of reasons on one reading. And then ACAS says this: the law also applies to people who have been on furlough and have not been able to reasonably use all their holiday in their holiday year. Now, it might be argued that there's some ambiguity here, because is ACAS saying that the fact that you're on furlough means that you can't reasonably take your leave? Now, if you ask Bayes what they say, the Bayes answer to that question is no, or at least usually no. They say that workers who were furloughed are unlikely to have needed to carry forward their statutory annual leave, as it would have been easier for them to take it during the furlough period. But when the furlough scheme was in place, Bayes said this about requiring workers to take leave while they're on furlough. So they said the employer should consider whether any of the restrictions that the worker is under, such as the need to socially distance or self-isolate, would prevent the worker from resting, relaxing, and enjoying leisure time, which is the fundamental purpose of holiday. So I would argue that we can see how the extent to which a worker can get the rest, relaxation and leisure might be relevant to the question of reasonable practicability. Now, how do we think the tribunal is going to read reasonably practicable? I suggest that this is going to be a matter of degree. It's unlikely to simply be or solely about the business capacity to be without the worker, although that's clearly very important, as the Bayes guidance suggests. The nature of the restrictions that were in place at the relevant time is going to be relevant. And just to expand on that, if you have, for example, a leave year that finished in, let's say, May of 2020, so you've got March, April, May, and in that time, of course, the restrictions were very harsh. You could only go out for an hour at a time. If you were clinically vulnerable, you were being told to stay at home and never leave your house, even for essential shopping. So the nature of the restrictions at the time is going to be relevant. And also the nature of the risks to the particular worker, I suggest, are going to be relevant. And that's all in accordance with the ACAS guidance. But I think, in addition, it will be interesting to see what weight, if any, is placed on the broader purpose of holiday and whether it can be fulfilled, in particular for furloughed workers, where there may be no material difference between being on furlough and being on holiday. And so this may well be an opportunity to revisit how we think about the purpose of holiday in the light of a once-in-a-century, or perhaps even longer, global pandemic. Thank you very much for your attention. If you have any questions about this topic, you can, of course, email me, and I'll hand over now back to Jude.
Right, thanks everybody. I hope you're suitably refreshed. We're going to kick off our second half now with Jason Braier talking to you about flexible working.
Thanks very much, Jude, and welcome everyone to the second half. I hope you're suitably, you wet your whistle suitably for a very exciting half with the three of us to come. So flexible working. Lockdown happened, and with the click of the fingers, we all entered, perhaps for the first time, the world of flexible working. Whether it was that we were having to work from home rather than in the office, or we're having to work flexible hours because our primary job now was as teachers or as childminders. And it's really an explosion in flexible working and the understanding of it. And the question in this talk is, what's the impact of that been or likely to be on the statutory scheme for flexible work and how it's going to operate? Now, I know that before the break we had a quote from Gandhi, and I'd like to start with a quote from a group of great statespeople about predictions. Because the Spice Girls, when they started their career, they said, if you want our future, forget our past. Now, the way that I look at legal predictions is that if you want to predict the future, you need to look to the past. So what I did was I looked for something that was going to be reliable, something that was going to be trustworthy, something that was going to give me a real sort of cast iron assurance about what is going to happen so that I could reassure you all. And I found the government's election manifesto from the 2019 election. And this is what they say about flexible working. This is the promise they make. We will encourage flexible working and consult on making it the default unless employers have good reasons not to. Now, many of you may say, is that not just a promise about the status quo? Because if you pass the threshold and can make a flexible working request, the employer has to consider it and can only reject it on one of 8 specified reasons, which, if substantiated, one must consider to be good reasons. Now, that was the promise, and to be fair to the government, they've at least already met one word of it. They have consulted, There's a consultation on the go at the moment. It finishes on the 1st of December. If you haven't responded to it, I urge you to do so. It takes about 15 minutes to do so. And this is what they've said about making flexible working the default. They said, well, we thought about moving from the right to request to the right to have, thereby precluding the opportunity for the employer to reject an application for flexible working. But we've decided that's not sensible or practical, so we're actually not going to consult on that. Now, a couple of paragraphs later, they then say, well, so how are we going to make flexible working the default? We're going to encourage better conversation between employer and employee. Now, you may think that that's a little bit of an empty gesture, but I don't want you to go away from this thinking that this is a valueless consultation, because it really isn't. There are 5 key proposals. The first is to make flexible working requests, or statutorily protected requests, a day one right. At the moment, you have to have 26 weeks of continuous service. And the government said, look, if we make it a day one right, that really gives a nudge to the employer to think carefully about it when they are putting their advert together and going through the application process. Now, they could have given a bigger nudge, and they did consider to do so in a previous consultation about whether the employer should, on their advert, say what their approach to flexible working is. But they've decided not to consult on that here. But in any event, they're looking at making it a day one right. I suspect they'll do so. It only needs secondary legislation. And speaking personally, I'm in favour of anything that limits the amount of time an employee has to tread the inconvenient waters between work and out-of-work responsibilities. Looking then onto the second of the bullet points, the second of the proposals, do the Section 80G business reasons to reject an application remain valid? Now, there are 8 reasons under the statute. There's the burden of additional costs, the detrimental effect on the ability to meet customer demand, inability to reorganise work among existing staff, inability to recruit additional staff, detrimental impact on quality, detrimental impact on performance, insufficiency of work during the periods that the employee proposes to work, and planned structural changes. What the government says, and I agree with them on this, is that that's pretty comprehensive and it's a pretty sensible list. I like the discipline of an employer having to pick one of a specified list of reasons rather than having carte blanche. So we'll see what happens there, but my prediction is that nothing on that will change. I want to skip the third bullet and move to the first part of the fourth briefly first, removing the 12-month bar. As things stand at the moment, if you make a statutory flexible working request, you can't make another one within 12 months. Now, that doesn't mean you can't make an informal request, and it doesn't mean that if you make a request that has an Equality Act angle to it, the employer can just ignore it because you've already made one in the last 12 months, as one of my clients learnt to their cost a few months ago. But it clearly, to my mind, makes sense to remove that bar because the exigencies of life don't wait for 12 months after you've made a request. The partner, for example, who suffers a serious or major illness and changes all of the employee's home responsibilities. But there's also a second technical reason as well. If you make a request and then you think, actually that doesn't do quite what I had hoped for, I'm just going to amend it a little bit. Or you speak to the employer and the employer pushes back and you think, actually if I modify this slightly, I can meet their concerns. Technically speaking, that modified request is a second request within the 12-month period and therefore won't have the statutory protections. And that clearly is self-defeating. And one can see that again when one looks to the essence or the purpose behind the third bullet point, requiring the employer to show they've considered alternatives before rejecting a request. So the suggestion here really is for another potential statutory nudge, so that those that are dealing with these matters get out of the mindset of, well, either I approve or I reject, to a mindset where there's this great area of potential compromise and potentially forcing the employer to think about that. Now, many good employers, and I'm sure all of our clients, would do that anyway, but the government's looking at whether that can be given some statutory teeth. So the second part of the fourth of the bullet points, this 3-month decision period. Now, at the moment, the employer has 3 months from the date of the request to give a final decision, including any appeal that's within that period as well. The question is, should that be foreshortened? Now, doing what the Spice Girls told me not to do, and looking back to the past, when one goes back to 2014, or the legislation before then, there was 28 days between the date of request and having to set a meeting, and 14 days thereafter, you had to provide your decision. And then there were separate deadlines for appeals as well. You know already that I like to limit the amount of time the employee has to tread in the inconvenient waters, and it won't be surprising to you that I think that actually it may be sensible to shorten the time, especially in circumstances where already under the statute there's the opportunity for employer and employee to agree either upfront or retrospectively to extend time. Now, the final bullet point, the final proposal, is really more of an amplification rather than a change to the current statutory scheme, because one can already apply for a temporary flexible working arrangement under the scheme as it stands. But the scheme says nothing about it. Indeed, the ACAS code says nothing about it either. And the government's concern is that people don't realise and they're not making use of it to that effect. So the question the government's asking is, should we do something to amplify? Should we do something to make that more clear so that people understand that more than they do at the moment? So those are the proposals. As I say, I think there is value to them in improving the current system. I have my own wish list that falls outside of the consultation, and they form part of my response, but I don't imagine that Santa is going to bring them to me as actual changes on this occasion, although there is a task force looking at flexible working as well, so you never know. Now, the first is this. The employer is required, when they receive a request, to deal with it in a reasonable manner. Now, what does that mean? Well, the statute is completely silent on it. Again, going back to 2014, the statute wasn't. It was quite prescriptive. I prefer certainty where there is uncertainty, and at the moment you have to turn to the Code of Practice. And the Code of Practice says at its start merely that this is best practice. Query whether a failure to comply with best practice is a failure to deal with something in a reasonable manner. We don't really know the answer to that. It probably depends on context. And I recognise that under Section 207 of Talker, the Employment Tribunal has to give consideration to a relevant code of practice, but we can't be particularly clear on it. Now, I know that when one turns to unfair dismissal, and when one looks at Section 98(4), there isn't that prescription in the statute, but we have an array of case law there which we are never going to get on flexible working. The second thing on my wish list relates to the opportunity of an employee to bring a claim on the basis that the employer, in rejecting the application, did so on the basis of incorrect facts. And my problem really is the wording of that. And I find it very difficult to tally the wording with the statutory scheme and with the case law. Because the obligation that the employer has on receiving a request is to only refuse the application because he considers that one or more of the following grounds apply. So it's very much subjective wording. It doesn't have that subjective-objective balance that you get, for example, in Section 26 of the Equality Act in respect of harassment. And in many respects, that should really be an empty vessel in circumstances where the statutory scheme doesn't require the employer to give underlying reasons for hitting on a particular ground, a particular reason to reject, and the statutory scheme doesn't even require it to be in writing. I mean, the Code of Practice says it's best practice, but you've heard my thoughts on that. Now, the only teeth really given to it comes from the case law, and it's a case called Commotion and Rutty, decided 15 years ago. And in that case, Miss Rutty was a grandmother, and she took on childcare responsibilities. She was a warehouse assistant. She sought to go down from, I think, 4 days to 3 days a week. She made an application to her employer. Her employer rejected it on the basis that it would detrimentally impact on the performance of the warehouse. She brought a claim. Now, the Employment Tribunal, when they considered the claim, said, "Oh, employer, you've relied on this ground, but you haven't actually investigated this. So we're going to delve into this and delve behind your reason. And actually, using our industrial experience, we think this could have been done without that detrimental impact." And the EAT said that was okay. Now, I've got no problem with tribunal scrutiny of the reason given. I just find it difficult to tally with the words incorrect facts, and I think that could be improved. The third and final thing on my wish list, Section 80I of the Employment Rights Act is the remedies section for flexible working, and it has 2 remedies. The first is an order for reconsideration of the application. The second is compensation up to 8 weeks at the statutory maximum, so a little bit over £4,000. And I wonder whether or not there will be a benefit to a third potential remedy, analogous to an extent to that used for reorganisations, in allowing the tribunal to order the employer to employ the individual in a manner consistent with the flexible working request. And perhaps if the employer says, no, we're not going to do that, as they can do with re-engagement, sorry, I think I said reorganisation before I meant re-engagement, a penalty increase in the compensatory award. Now, finally turning then back to the question of the impact of the pandemic, well, we've all had, as I say, forced flexibility imposed upon us. We have a far greater understanding within our workplaces of flexibility and what is possible. Employers have had to really turn their mind to how to minimise the impact of flexibility. You know, we are all now Zoomers and Microsoft Teamers, where many of us, certainly barristers, weren't before. Well, I speak for myself at the very least, if no one else. And I say what this means is that there is a far greater level of empirical evidence as to flexibility working, which makes it more difficult for an employer to happily rely, in many cases, certainly not all cases, on the grounds of rejection. And if one turns to the Equality Act and an indirect discrimination claim, as Jill spoke about, makes the objective justification defence more difficult to succeed on. If one looks at the failure to make reasonable adjustments claims that Aysha was talking about, makes it more difficult for an employer to say, well, actually, this wouldn't be a reasonable step as a defence to those claims. And if one were to turn back to the Employment Rights Act and a constructive unfair dismissal claim where the employee has resigned in part or in whole because of the rejection of their request, it makes it more difficult for the employer to get within that first bit of malic without reasonable or proper cause. The employer acted in a manner calculated or likely to damage or seriously destroy the relationship of trust and confidence. So that's where I think we're at. Those are my predictions. It might turn out in 2-3 years' time that they're all wrong, but we shall see. I'm going to now leave you with my email address so you can ask me some hard questions, and hand over to Kat, who's going to talk about the price of work at home.
Thank you very much, Jason. Well, working from home, doesn't that mean staff are now better off with no commuting costs or lunches at Pret? Why doesn't the employer give them a pay cut? That's what I'm going to be suggesting. In August, an unnamed cabinet minister was reported in the press as saying civil servants who refuse to go back into the office should be paid less than their colleagues who do return. The minister was quoted in the Daily Mail as saying people who've been working from home aren't paying their commuting costs, so they've had a de facto pay rise. So that's unfair on those who are going into work. If people aren't going into work, they don't deserve the terms and conditions they get if they are going into work. What do you think about that? Now, the Business Secretary, Kwasi Kwarteng, was very quick to confirm that the policy reported in the Daily Mail would not be being applied to civil servants. But over the summer, we heard another report from America this time. In Silicon Valley, Google is apparently proposing to use a work location tool. That means that to some extent staff pay would be based on where they live rather than what they were doing or what seniority they held. So an example was given of an employee living in Stamford, Connecticut, which is an hour from New York City by train. They'd be paid 15% less if they work from home, while a colleague from the same office who lived in New York City would see no cut even if they continued to work from home too. Critics pointed out this has a negative effect on diversity because those living in poorer areas will have less incentive to apply to Google, and if they did end up working there, they might find themselves ghettoised as second-class citizens who can't afford the smart addresses. So you can see the idea of paying people differently for the same work in the same company, depending on where they live, is bound to be controversial. And these recent stories have led to speculation in the press about what circumstances, if there are any, employers can reduce the salaries of those who choose to work from home or are obliged to work from home as the pandemic eases. So let's look at some of that in more detail. The price of financial benefits to employers of working from home. Well, first of all, employers should ask themselves this: why do you need to cut the salaries of your staff if you're considering it? Would the financial benefits of reducing employees' salary outweigh any likely negative practical effects in staff relationships and the wider PR? After all, the employer may already be saving money because if staff are working at home, they're likely to be able to rent smaller office premises, reduce cleaning or utilities bills, equipment, furniture, catering. All of those bills are likely to come down. But if an employer is still considering this move, the starting point has to be the contract of employment. As we know, pay is central to the work-wage bargain. Only if there's a very clear provision for a salary reduction or for the employer to pay a salary that varies according to the location of the work will it be safe or sensible for the employer to consider unilaterally reducing a worker's salary if they work from home. London waiting is an example that's been discussed. After all, there is sometimes more salary given to those living in the obviously expensive part of the southeast. But as we know, the tribunal will closely examine the terms of any contract before deciding whether the employer can unilaterally reduce the employee's salary. Without that watertight contractual clause, a failure by the employer to pay the salary that's been agreed is likely to be a repudiatory breach of contract and potentially lead to a claim for constructive unfair dismissal. And we see one of the key cases on this, the Cancel Fitzgerald case mentioned on the slide. Lord Justice Judge said, "In reality, it is difficult to exaggerate the crucial importance of pay in any contract of employment where an employer unilaterally reduces his employee's pay or diminishes the value of the salary package. The entire foundation of the contract of employment is undermined." So there we are. An employer may consider whether to fire and rehire. That's a practice that's attracted a lot of coverage in recent months. It's legal, but it's, I would say, morally unattractive. And obviously the unions are opposed to it. As we know, it involves the employer firing the relevant people and then inviting the dismissed employees to reapply for their jobs as available to lower rates of pay. Obviously this could also lead to claims of unfair dismissal and discrimination depending on the pool of those involved unless it's handled very carefully. In September this year, Weetabix tried to do this, tried to reduce staff pay by about £5,000 a year through a fire and rehire exercise, which led to strike action and negative publicity. Earlier in the pandemic, British Airways and British Gas also tried it, and while British Airways came to an arrangement with the unions, British Gas was widely condemned for sacking engineers who refused to sign up to the new contracts. Another problem possibly arising for the employer who wants to reduce the salaries of those working from home would be, if, as it seems likely, more women choose to work from home than men, an indirect discrimination claim arising. As the practice of paying people who work from home a lower salary is more likely to impact on women than on men. Arguments may also arise that younger staff and those from a different racial background may also be adversely affected by such a policy. If, for example, the higher cost of commuting is leading those groups to choose to work from home, or possibly vaccine nervousness, as Jill had discussed in an earlier talk. Staff who choose to work from home because they find it easier to manage care responsibilities, life with a disabled partner or child, may also find they could bring an indirect associative discrimination claim if they are obliged to settle for a lower salary. So there are plenty of reasons there for employers considering this to think very, very carefully before putting that into practice. Now, what about working from home from the employee point of view? That unnamed cabinet minister quoted in the Daily Mail does have a point. After all, working from home may enable the employee to save money in various ways. Commuting, lunches, that cheeky G&T on the train home, the daycare childcare arrangements, office appropriate workwear. You can save money on all of those if you're sitting in your bedroom in pyjamas all day long. So it's also true that you can arrange your day more conveniently for you. You could use commuting time to take exercise, do personal admin, etc., etc. So some employees may be prepared to accept a lower salary if the alternative is to lose their job or to return to a soul-deadening commute. But the employee working from home is likely to have a few disadvantages to think about as well, perhaps some unexpected costs. Electricity, broadband, home insurance may rise. Will the employer agree to cover any of those? What about providing a laptop? Will the employer do that? What about stationery, printer ink, things of that sort? Does the employer's expenses policy need to be revised? And there may be tax implications to consider. Now, when we did a run-through of this talk this morning, Iris told me that the tax bit was really boring. And she was right. So you'll be glad to know that I'm going to skip through it in about 30 seconds. Tax, okay. Expenses, yeah, you may be able to offset a few things, but you've got to be really careful not to fiddle it. Don't even think about trying to claim your commute. Laptop provided by the employer, yeah, have a good look at the HMRC website. Right, so that's the tax bit done with. Oh, hang on, want another slide. There we go. Oh, that's tax as well. I might be wanting to move on again. Right. So, more generally, there may be another price to pay for working from home, the lack of social interaction with colleagues. It's been touched on by some of the other speakers. Being kept out of the gossip loop, the water cooler chat, the hanging out by the photocopier, fancying the check from accounts, whatever it is. A fear that lack of visibility may make you less likely to obtain promotion. That's another thing that's mentioned. There was an article in the Times just last Friday on the front page, working from home will harm your career, women warned. Thanks, it's always women who get this end of the stick, isn't it? So women who work from home are at risk of falling behind in their careers as two tracks develop in the workplace, according to a senior figure at the Bank of England. An economist called Catherine Mann said that the difficulty in accessing childcare and pandemic-related disruption to schooling means many women are continuing to work from home. The economic downturn had hit women disproportionately, and the pandemic was a she-session, she said. Unnecessarily, in my view, but we see her point. So it's actually quite an interesting article, apart from the ghastly jargon, suggesting that there is a sort of social capital value, a sort of hidden value in physically appearing in the office. Whether that's good or bad, I can't really say, but it certainly seems to be the case that exists. So, concluding points. We've got the tips here. Employers should think about creating a home working or hybrid working policy to deal with the new work environment. And ACAS has some suggestions of how to do that. It's worth thinking about things such as confidentiality of data, health and safety, Appraisals. What about appraisals? If your manager needs to come and meet you, would you allow them to come into your home? Things of that sort. It's also worth thinking about expenses. Do you need a new expenses policy? What can they claim? What about printer ink, stationery that they used to steal? Where do they get it from now? And I speak as someone who's still using staplers from a job I left 15 years ago. The statement of terms of employment may need to be updated for home workers to be accurate. So those are my thoughts.
Any questions?